Now, it's every political godfather's worst nightmare, isn't it? A political godson is chosen, apparently compliant and dutifully submissive, but soon after taking office, he fails to submit to the imperial godfather's authority and refuses to do what he's been told to do. And with each passing day, the godson, no longer wanting to be the passive, meekly obedient object of political beneficence, begins to cause catastrophic convulsions and to increase his political strength as he steadily wards off the perceived maleficence of his benefactor, but not before both sides have turned the land, in this case River State, into a degraded, scorched wilderness. It all conjures up a pre-colonial Niger Delta, doesn't it, with slave-trading warlords battling each other for control of trading routes. And according to a This Day newspaper article by Chidi Amuta, the great-grandchildren of those slave-dealing warlords have become present-day politicians. But the bloody contest for supremacy and the warlike instincts among the rival houses of old live on in what is modern Nigeria.
These people that have come to fight this application, as we are talking, they are not members of the River State House of Assembly. In the eyes of the law, the River State House of Assembly has invoked the constitutional provisions, Section 109, subsection 1G. And they have invoked it. It's a completed act. And there is an order of River State High Court that has restrained these former members of the former speaker, what's his name again? Honorable Martin, and his former members and his former colleagues from parading themselves, from forcefully gaining entrance into the River State House of Assembly complex. So, and the only thing they have to do if they believe in rule of law is to go to court, appeal the ruling, appeal the procedure that suspended you. Let us know whether Wike will also go overnight and expunge Section 109, subsection 1G of the 1999 Constitution. Let him go and expunge it. We now know that we are a Republic of Wike. We now know that we are a Republic of, we now know that we are before the Federal High Court of Wike. Let him go overnight, go to the National Assembly and expunge Section 109, subsection 1G of the Constitution, so that to bereave the members of the River State House of Assembly the power to invoke that section of the Constitution. They have already invoked it. So in the eyes of the law, these people, Honorable Martin and his colleagues, they are former members of the River State House of Assembly, and they should go to court.
And that's Okere Kingdom Nnamdi there. Well, for the latest on the political crisis in River State, I'm joined now in the studio by the lawyer and human rights activist that you saw in that video, Okere Kingdom Nnamdi, who's part of a group of legal practitioners who've teamed together in defense of democracy in River State. Thank you very much indeed for joining us.
Thank you so much. It's always a delight to be here.
Yeah, so once again, Nigerians gripped by legal wranglings, this time with regard to the political situation in River State. Tell us more about what you were doing in court today.
What we did in court today, yesterday, while I was in my sitting room, I stumbled into a live media briefing by the CUPP, where they alerted Nigerians that there was going to be a court ruling that will be delivered in Court 8, Honorable Justice Okorewo's court, today with respect to the political brouhaha in River State. And we, as lawyers in defense of democracy, not just in River State, in Nigeria, we have intervened in several issues, that has to do with rule of law and sustaining sustainable constitutional democracy in Nigeria. And while we're listening to the group, address the press, we decided as lawyers in defense of democracy to go to court this morning to find out exactly what happened and why would there be a black market ex parte ruling, by Honorable Justice Okoro. And of course, in recent past, the judiciary has been in the eyes of the storm over corruption. Of course, the Court of Appeal judgment with regards to Kaduna State Guba is still very fresh in the mind, where different issues were resolved, and at the end of the day, the appeal was dismissed. And of course, we went to court this morning, and of course, there was a twist. And we found out that what the group alleged yesterday during their media briefing is very well correct. They have not done anything that one would allege not to be wrong. What they alleged, we were in court and we searched for the matter. The registrar of the Court 8 told us, as lawyers in defense, not only me, we were about 3 lawyers that went there. He told us that yes, there is such an application, the same suit number as the same that is circulating in the social media, the same suit number. But he now rather said that the application came up on Friday and that the judge delivered ruling on that same Friday. So which is a twist from what Nigerians were alerted. The Nigerians were alerted that it will be delivered today. Right. And from what we found out, no ruling was delivered on that Friday, either in the open court or in chambers. So we are seriously suspecting that something is fishing. The judiciary is about to be brought to the ridicule, and it calls for stringent measure, particularly the Chief Judge of the Federal High Court would have to exonerate himself, because this application was filed on 13th of December. That was on Wednesday. And by Thursday, Friday, it has already gotten to Court 8. And from what the registrar of Court 8 told us, that the judge sat on the application on Friday and delivered ruling on Friday, as opposed what we heard in the media, the rumor circulating that he was to deliver that judgment today. Right. And okay. Well,
let me just come in there, because there's a lot to unpack from what you've told us. Are you saying that the document that was circulating on the internet about that particular ruling that you're talking about is fake?
It's the same application that was filed, the same suit number.
But the judgment that was supposedly delivered, the court is denying that. Right. Okay.
That rather, the Honorable Justice Okere will deliver this ruling on Friday after taking the application, and that if we want to have a copy of the ruling, that we should apply officially.
So you applied for it?
We applied officially to get
for the certified true copy
of the ruling. We applied and we paid, and we are hoping that by tomorrow, whatever that is contained in the ruling, because it should be handwritten, and of course you will not be allowed access to look at the handwritten court proceedings of the court. So it will be typed out, signed and sealed, and you can apply for CTC of the ruling. So, but now, why we are worried as lawyers in defense of democracy is that these are courts of coordinate jurisdiction. Both the Federal High Court and the State High Courts are courts of coordinate jurisdiction. And the current Speaker of Rivers State House of Assembly, that has the backing of the Rivers State Judiciary, they have completed the act. They have invoked Section 109, subsection 1G of the act, and they have notified INEC that these people have been suspended. They are courageous enough to do it. In fact,
they've lost their seats.
That House of Assembly should be commended. So that is what ought to be done.
Yeah, but I need to be just clear. I need to be clear on what is going on now. I mean, you have, because one would assume that if the judgment that was said to have been delivered on Friday was in fact delivered to the benefit of those
We're not saying what is contained in the
I know, but what I'm saying is that if it was to their benefit, you would think that by now they'd be asserting the fact that they actually got the judgment that they required.
That is why we are suspecting that there's a foul play somewhere. There is something must be investigated by not just the Chief Justice of the Chief Judge of the Federal High Court, but the National Judicial Council. Something really have to be investigated out of this, because we are suspecting that it is either what is circulating in the social media is correct, and now they are hell bent perpetrating the illegality because it's an abuse of court process. These two courts have equal power. What they should do, members of the River South Assembly, having declared their seat vacant because they come to another political party, which is expressly provided for in section 109, subsection 1G of the Constitution. Having done that, what they should do is to go to Court of Appeal and appeal, not to come to another court of competent jurisdiction to get a counter ex parte application so that the judiciary will not be brought to ridicule. That is what we are against. That is what we are calling on the NJC to investigate. Right. To know the circumstances under which a court, a high-ranking court like Federal High Court, should know that these two courts are courts of competent jurisdiction. So you are giving a counter ex parte order to counter an ex parte order.
Well, I mean, the point is that
River State High Court, where you know that their only judicial legal remedy is to go and appeal, and appeal against.
That's a very important legal point that you make there. However, you don't know yet what that court that they went to.
We don't know what the ruling is all about. So the court, like I said, the court.
So I think we have to wait to see what they say tomorrow.
What is circulating on
so they denied it.
That is not their ruling. Right. We are not about to deliver any ruling today. That they. Honorable Justice Okere sat on Friday, had the ex parte application, and delivered ruling on that ex parte application that same Friday.
But they're saying that the ruling that they delivered on Friday is not the same thing that is circulating on the internet.
What is circulating on the media.
Right,
and now, the only right we have is to make an application for CTC of what happened on Friday.
Absolutely. And you've made that application.
That we have done. Right. And we are hoping that the relevant authorities, particularly the Chief Judge of the Federal High Court and the National Judicial Council, should in fact by now they should call for the file. They should investigate the file. They should know exactly what happened, because the judiciary, this constitutional democracy has to be sustained. The judiciary must not be brought to ridicule because of one Wike. If it is true that Wike has pocketed the president, has pocketed the chief of staff, Wike will not also pocket the Federal High Court. So far as we know, the Federal High Court of Nigeria still has reputation. This kind of application, you could see it at the FCT High Court or some other state high court, particularly during political.
Well, I mean, let's be clear
that the Federal High Court, we know, has a reputation of resisting this kind of.
Well, let's be clear that there is no evidence that Mr. Wike has put the president in his back pocket.
I mean, that is what is circulating on the social media.
Anyone else. But let me just ask you this, because we're going to wait to see what exactly is contained in that certified true copy when you get it. And please let us
claim that they delivered on.
And please let us know, because we obviously want to see that. But beyond that, the laws are pretty clear, aren't they, on what the consequences are and should be for a legislator who defects to another party. So what would be the grounds for the courts finding in favor of these River State lawmakers, assuming that it did?
Well, what the court granted is an ex parte application restricting them from obstructing
until the case
is heard. And of course, the court adjourned to the 21st of December for hearing of the motion on notice, because for a court to hear and grant your ex parte application, you have to file along that ex parte application a motion on notice. And most courts will tell you, put them on notice, or look at the ex parte application, grant all of the prayers, or grant partially some of the prayers and tell you to put them on notice, because the interest of justice requires that parties in a judicial proceeding have to be served. They have to be aware of a pending matter against them so that they have the right to defend themselves. So what the court has done is to grant this ex parte application, which is an interim order that usually lasts for 7 days. At the first instance, there could be an application to extend it, but then what is before the court is the substantive suit, where they will not be seeking the judicial interpretation to section 109 subsection 1G, and whether or not the members of River State House Assembly, because as I'm talking now, the former speaker, Right Honorable Martin Chike, and his colleagues, they are former members. So what will now happen is for the court to interpret section 109 of the Constitution to know whether this the new speaker, Honorable Edinson, and his members follow the legal procedure in invoking that section of the constitution. But as for whether that section is there, it is there. And it is sacrosanct that as soon as you defend to another political party, unless that party is in crisis. So those are the issues. That is a proviso, except there is a crisis in that political party. So now, I would even want to commend them for having the courage to invoke that section of the constitution, declare their seat vacant, and notify INEC. Then they have rights. The former speaker, Honorable Martin Chike, and his colleagues, they have right to go to court to challenge the procedure of what these people have done, and to also go on appeal to seek to set aside the ex parte application, and of course enter into the substantive matter, not to come to federal high court to get their own counter. I think
you've made that
is
point.
What we are.
Let me just put out this piece of news that we're getting, that President Tinubu is, we're told, currently meeting with stakeholders from Rivers State. I understand that the Governor Fubara is there. I understand the former Governor Peter Odili is there. We don't know if Mr. Wike is there. But so that's an important piece of information. So there are moves behind the scenes to try and settle, to find a political solution. But I mean, let's get back to the legal issues, because of which you are obviously much more expert than many. Even though there is precedent for what you were talking about before, nevertheless, would you agree with those who say that this case about the lawmakers in Rivers State is likely to be a very important decision that the courts will take with regard to state assemblies, and it will probably reverberate much more than the precedents that have already been set?
Well,
because of the circumstances.
The circumstances. I mean, on the action that the Rivers State Assembly has taken. That's what we are talking about. There has been precedence, of course, on this matter. The PDP, you recall.
No, I understand that, but I'm saying that in this instance, because of the political ramifications and the consequences of what is going on across the country. You've got the president now wading in, bringing these people in. It's a much bigger political crisis. So whatever decision is taken by the courts will have greater resonance, won't it?
Well,
even in the face of the precedents that have already been set.
Well, you know, when the president intervened and a political solution is amicably sought and found, the law will also have a way to, you know, accommodate what has happened, because the matter is still subject to litigation. Like I said, they have invoked Section 109 of the Constitution and have announced that the seat of the former speaker and his colleagues are vacant. What I'm saying is that it is not sacrosanct. These other people has the right to go to court to challenge the procedure. That's what I'm saying. Not what we are against is coming to the Federal High Court to get a counter ex parte application that will bring judiciary to ridicule. So
and bring
confusion. So they have right to instruct their lawyers to enter appearance in that pending matter before Rivers State House of Assembly, and to also challenge the procedure under which their seats were declared vacant, whether the current incumbent speaker comply with the procedure. So in other words, the matter is still pending before the court. So if a political solution is sought and found, like you said, that the president is having meeting with the Rivers State stakeholders, if a political solution is sought and found, parties could still come to court and withdraw their processes, or enter a consent judgment, and the whatever agreement they reach can be entered as consent judgment.
Well, as I said,
what I'm saying is, even though the matter is before,
you've made that point. We understand it.
So whatever political solution the president is making, it's a step in the right direction, because political solutions is not is always encouraged.
I understand that. So when you get the documents, the CTC, do let us know. We'll be able to follow what is going on. I want to thank you very much indeed. Okere Kingdom Nnamdi is a lawyer and human rights activist and part of a group of legal practitioners who've come together in defense of democracy in Rivers State. Thank you very much.
Thank you so much.